The choice to pull your kid out of public school and homeschooling is not only not evidence of abuse or neglect, it's a very sane and rational decision, especially in this day and age. So using homeschooling as a choice that somehow triggers DCF involvement is completely unacceptable. If parents and families choose to live mostly private lives, the government doesn't have the ability to say, well, you're not out in public enough, so we're going to come in your house. This is just so beyond the pale, and given Connecticut's political leanings, I wouldn't be surprised if this advances. Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Joseph Clement, Content and Program Manager at Napa Legal.
You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. So this week, we'll be covering a Ninth Circuit case requiring a Korean spa to allow men into women's spaces. Then we'll go to a recent victory in the Supreme Court for religious speech in the public square in a case called Olivier that we've covered previously. And then we'll end with a new Connecticut bill that was introduced that would create some pretty serious problems for families who choose to homeschool their children. So let's start in the Ninth Circuit. This case is called Olympus Spa. So Olympus Spa, for a little bit of factual context, is a traditional Korean spa that requires nudity for many of its procedures and in certain areas. We'll get back to that, but I think it's really important to point out what this spa is, because I think a lot of people think of spa and you think of, a spa at a hotel or like a normal massage parlor where, you walk in, you change, you're under a blanket, nobody sees you. What's the big deal? But this spa apparently has many places where people are nude and in the same place. And so both as a matter of religious belief and to protect its patrons, who can be as young as 13 years old, the spa restricts admission to women. So a man called the spa asking to attend, and after being informed of its policy, he filed a complaint under Washington State's anti-discrimination law, WLAD, which we have covered, unfortunately, in some other cases recently, because it is quite burdensome and has very few exemptions that leave room for religious beliefs and practices. So the plaintiff here claims that the spa's policy of not allowing individuals with male sexual organs into women's spaces illegally discriminates based on his gender expression and identity. So the Ninth Circuit recently issued its ruling in his favor and denied rehearing, which forces the spa to either close its doors or violate its beliefs and subject women and girls to serious harm by allowing men into those often nude spaces. So the spa claimed that as applied in this circumstance, the Washington state anti-discrimination laws would violate its rights to free speech, free exercise of religion, and freedom of association. The Ninth Circuit obviously ruled against all three claims. So on each claim, we're going to go through, and then I'll offer a couple of quick thoughts. So first, the SPA claims that the non-discrimination laws violate the free speech clause because the law requires the SPA to post language stating that it doesn't discriminate based on sexual identity. And by the way, the non-discrimination laws in Washington define sexual identity as including gender identity and expression. It's pretty widely encompassing, which I would say alone, statutes can define their terms how they want to, but this is a unique bending of sexual identity. Usually you have sexual orientation and gender identity distinct. It's kind of a hodgepodge here, but in any event, sexual identity protection in Washington apparently includes people identifying as something other than their sex. And the court ruled that such language requirements that the SPA would be forced to post is a mere matter of fact and constitutes only an incidental and thus likely constitutional burden on speech. More on that in a minute. The majority also looked at the religious exercise claim, applied Employment Division versus Smith, and held that since the non-discrimination law is facially neutral, right, it doesn't target religion explicitly and is generally applicable, it's not an unconstitutional violation of the free exercise clause. I don't know if this is actually a misapplication of the law. This might just be yet another problem with the Smith framework, and we'll leave that. Lastly, since the SPA is a business and not a legally, quote, intimate and select organization, the court ruled that despite forcing the SPA to allow men into deeply private women's spaces, the law doesn't violate the guarantee of free association offered by the First Amendment. I have a problem with that one too. But I'm going to keep my analysis pretty brief here because we're just going to have to see if the Supreme Court takes this up. Maybe this will be the next fight, the next case that goes up on these kind of clashes between religious persons and organizations um, and the non-discrimination regimes, especially in states that don't have adequate exemptions. So I'll note that on a statutory level, there are two glaring difficulties here that would not be the case in other states. One, it's worth pointing out many states have caveats that despite sex non-discrimination laws, which are general, right? In most cases, you can't discriminate on the basis of sex in public accommodations. Many states have a caveat saying that it is not discrimination to have separate spaces for men and women in intimate settings, such as bathrooms and changing rooms. There is no such law in the Washington state non discrimination law, which is a problem. It is just worth pointing out that even other states that are generally hostile to religious exercise and don't have broad exemptions for religious organizations or religious exercise in their non discrimination laws, even in states like that, I believe Colorado is one of them that we've talked about in the past, where despite their lack of exemptions for religious organizations, there is a general carve out that says no in intimate spaces such as bathrooms, changing rooms, etc. Having separate spaces for men and women on the basis of biological differences is not a violation of the non-discrimination laws. Unfortunately, that is not the case in Washington state, which again is a problem. Second statutory note is that the Smith problem, right, that there's not really much of a religious exercise protection under the First Amendment because of Employment Division versus Smith, will be overcome in other states if they have a RFRA, State Religious Freedom Restoration Act. Washington state does not have one. So the statutory remedies here are not so good, and hence we end up at a place where the main arguments against this broad and problematic non-discrimination regime come down to constitutional claims: free exercise, freedom of speech, and freedom of association. So I'm not going to get too much into the legal precedent and where I think this is going to go. I just want to talk a little bit about the basic original principles behind non-discrimination laws and how they've been expanded and in some cases warped to create massive problems for religion and also just sanity. So, bans on sex discrimination, I think everybody kind of on a common sense level knows this. They're meant to ensure that women are not excluded from jobs, from schools. That's why these were created, right? You have like the Civil Rights Act on the federal level, making sure that women aren't excluded from schools altogether or from certain academic programs. These laws were never meant to eradicate single sex spaces. Again, it's not primarily an analysis of the intent of the legislators, but I think if you go back to the 60s, 70s, 80s when these things were being formulated, although Washington's, editions of sexual orientation and gender identity are rather new, but most people at the time that these laws were first being fitted out did not think that this is what they were doing, was getting rid of like men's and women's bathrooms or changing rooms or single sex spaces in general. So the emergence of the transgender movement really requires, I think, a reexamination of these laws on a really high level. It's one thing to say that a person shouldn't be banned from a certain space or from a certain job because of his purported gender identity. That can be problematic enough, especially if you're talking about a religious organization being forced to hire somebody who is living in a way that is antithetical to the faith. But laws like this go much further. This isn't about keeping somebody out of an entire field, right? This is arguing that someone's subjective opinion about his human nature and his sex trumps objective reality, and that's insane. The problem is further compounded when we're not talking about, for example, a an entire industry that says no, we're not going to have women as lawyers, or we're not going to have women working at this company, where the harm is limited. Eh, Sorry, let me rephrase that. So my point is that we're not keeping men or women out of entire fields, right? Law, medicine, and so on. What we're talking about here is very narrow, specific organizations, places that are for one sex, and when we just get rid of that's a huge problem. And again, we're not talking about like a men's only cigar lounge or something where if you allow a biological woman who identifies as a man, I think that's still problematic because single sex spaces are kind of natural. But in that case, the harm to the club members is only social. right? It might mess up the conversation or the general atmosphere or dynamic when you allow people of the other sex into these places. But again, it's a social harm. But here we're talking about something much greater. We're talking about physical harm and danger, right? This is a women's only space, not just for the sake of having a women's only space, which again, I think is okay. But here, women are walking around nude to receive these spa services. So allowing men into those spaces is not only a social harm, but it's physically dangerous. And we've seen sexual assaults and other issues that have come when you allow men into women's bathrooms and changing rooms and so on. And so the danger, the harm there is pretty serious. So all that being said, unfortunately, I think it's very unlikely that we'll see any statutory changes in the state of Washington to remedy the situation. I don't think they're passing a RFRA or widening their exemptions for religion or anything else in that state. So I'm glad this lawsuit is proceeding. I think the arguments on religious exercise, freedom of speech, and freedom of association grounds is the only way practically to attack it in a state like this. Um, and I'll just say that I think the religious exercise argument is hard in the Smith era. So, what legal issues should we be looking at? I think we look at the speech and the association arguments as the ones likely to prevail if this does go up to the Supreme Court. And I'll just make two quick points on these arguments. First, I think it's troubling that the Ninth Circuit can rule that the spa is not a legally intimate and select organization, as we said earlier. That might be true in that it isn't like a membership club, right? It's not a private association that only allows men in by membership only, or women in this case. But this isn't simply a typical resort type massage parlor. As I said, there's a lot of nudity. This changes the atmosphere. This makes the mixing of the sexes problematic. So if there's a legal distinction that says, okay, this is not an intimate and select organization, all right, maybe under whatever definition of intimate the court is working with, but it is, in fact, an intimate um, atmosphere, an organization, right? It's not a bar, it's not a restaurant, it's not a normal place of business. It's a massage parlor, a spa where people are walking around in the nude. So you can use whatever legal term of art you want and say it's not intimate, but common sense says this is an intimate atmosphere where it is not appropriate to mix sexes. Second, I think the court is just wrong that the message that the spa is required to post in its facilities is language that is a mere matter of fact and therefore constitutes only an incidental and likely constitutional burden on speech. Right? This is the message that would have to be put up in the spa to keep them open forces the speaker to say that men and women are not different and that people with male genitalia can be safely nude in women only spaces. That's not neutral. It's not fact based. It's highly controversial and a false statement, by the way, that depends on a highly political issue, right? That these governments are declaring that men and women are not meaningfully different. This isn't just about preventing discrimination. This is forcing speech, requiring people or organizations to hold that men and women are not different. Than having nude women in a place is not, it's not problematic to also allow nude men in those spaces. So that's political speech. It's highly controversial speech to say like, oh, this is just a matter of fact. There's only an incidental burden on speech. That's just wrong. That's changing the game to say that, oh, these are just accepted facts. No, they're not. Um, I could go on, but I kind of want to shift over to Joseph. I know you've done a little bit of the legal analysis on where you think this is going to go. I just wanted to back up and talk some first principles that if we're getting to this point where keeping men out of a place where nude women are walking around for long amounts of time in intimate settings is somehow not a legal problem and is indeed a legal requirement that you can't have these sex segregated spaces. This is a huge problem and likely an end to most of these sex segregated spaces because not being a woman, I do know enough women to know that most of the women I know would not go to a spa where they are going to be nude for long amounts of time if men are allowed to walk around nude in those same spaces. Again, this is not particularly controversial. This is not just a matter of discrimination. It's kind of common sense and human nature that would dictate that these spaces being women's only is completely reasonable. So I will stop there.
Yeah, Frank, and I absolutely agree. Really reading throughout this opinion, one thing that really stuck out to me, and you could probably add some color to this as a resident attorney, is that the government's alleged interest in this case is completely misnomered by the court. So we have these for anyone unfamiliar, we have these various tiers of scrutiny that courts apply when government activity is challenged as unconstitutional. At the most stringent and most strict and kind of least deferential to government activity side is strict scrutiny, which means there has to be a compelling government interest, and the challenged activity has to be the most narrowly tailored means to accomplishing that interest. On the other side, on the kind of most deferential, easiest to pass, we have rational review, says there has to be an important government interest, and the challenged government activity has to be rationally related to that interest. And depending on the type of challenge, there's kind of these different levels of intermediate scrutiny somewhere in between. But all of them depend, at least in some part, on the government's interest, right? Is there a compelling interest? Is the means either narrowly tailored or rationally related to the interest? And in this case, the circuit's analysis defined the government's interest as being, quote, preventing discrimination. That's completely incorrect. Washington's government here isn't trying to prevent discrimination. They're trying to enforce the state's preferred ideology. Frank, in your recent episode with Danielle White that went live last Friday from Heartbeat International, you talked about how the pro-choice movement quickly moves from its language of this lovely tolerance to being very intolerant of opposing views and silencing dissent. You were talking about this movement to silence pregnancy resource centers that advertise abortion pill reversal. You go from tolerance of all people into intolerance of dissent, maximizing choice to actually minimizing choice and getting rid of choices for people. I think something really similar is going on here with Washington's quote unquote anti-discrimination law. Tolerating everyone's beliefs here quickly turns into, if you don't think that a man can be a woman and can expose himself in private places, then you're a bigot and you need to be shut down. This isn't about discrimination. This is about ideology. So I'm unaware of any serious case law where you can challenge a court's interpretation of a government's interest. Here, this court's analysis of what the government's interest is completely misnomer, and it's painting the government in the best light when what they're doing is they're enforcing the state's preferred ideology about what men and women are onto these private and Christian organizations.
Yeah, I think that's a good point. I know we talked about this before we hit record, but I think how narrowly or broadly the government has to explain its interest is a huge factor here. Because you're right. If the state government says, well, our compelling interest or our interest here and is just preventing discrimination, so well, that's extremely broad. Like, what do you mean by that? That can be done in a lot of ways, and I agree. That's not a proper articulation of the interest here. What you're doing is putting men into women's spaces in a place where women are vulnerable. So I would like to hear the state articulate more clearly why this is an interest that the government has in making sure that men are allowed in spaces where women are nude, because we're way past just preventing discrimination in some broad sense there. So I would like a little bit more detail and color into what exactly the discrimination is that you're trying to prevent.
Yeah, yeah, absolutely. So with that, move on to our second case. It's one we've been tracking for a bit of time now. The U.S. Supreme Court recently allowed a Christian street preacher to challenge a quote unquote free speech zone law. This is Olivier v. City of Brandon, Mississippi, if anyone's been tracking it. So, for the facts, Gabriel Olivier is an evangelical street preacher from Mississippi. He'd often preach his faith near this public amphitheater. The city of Brandon passed a city ordinance that restricted protests near the amphitheater to a small, remote area far away from the entrance and far away from any pedestrian traffic. Olivier tried to follow the law. He said, okay, I'll go, I guess, to the space where I'm allowed to speak, but found it impossible to reach anybody with his message. Nobody could hear him. It was like way off to the side. Nobody walked by. So the city ordinance basically made it impossible for him to preach to people in a public square. This isn't in a private setting; it's in a public space. So he eventually said, "I can't talk to anybody here. I can't exercise my faith." So he left the permitted area and preached close to the amphitheater. In so doing, breaking the city ordinance, for which he was arrested and ultimately made to pay a fine with a suspended 10-day prison sentence. To which he pled no contest. Said, "I'm just not going to fight it. Pay the fine. Move on with my life." A few months after being convicted for breaking the city ordinance, he filed a Section 1983 lawsuit and asked for an injunction that would prevent the law from being enforced against him in the future. So he basically said, I kind of eat the sentence, whatever, I'll move on with my life. But in the future, this law violates my free speech and free exercise rights. He's asking for an injunction in the future only. So the lower courts dismissed his lawsuit, but the U.S. Supreme Court recently unanimously ruled that his case can proceed. So legally, this case centers around two things: Section 1983 lawsuits and the Supreme Court's 1994 decision and Heck v. Humphrey. So for Section 1983 lawsuits, for anyone who's a seasoned listener of the podcast or who kind of follows these things, it's probably a familiar concept, and it's a pretty simple idea. Section 1983 is a federal law that enables someone to bring civil action against a member of the government who has violated his rights. Here, Olivier is claiming that the city's ordinance violates his right to free speech. I think he might have claimed free exercise as well, and he's filing a claim under Section 1983 to prevent it from being forced against him in the future. And it's really important to note, and we'll get into this towards the end, that he's not asking the court to overturn his prior conviction. He's only asking for future relief. He's not saying, say that I was unjustly sentenced under an unjust law, get rid of my record, get rid of the fine. He's just saying, in the future, this shouldn't be enforced against me based on free exercise and free speech. So the lower courts dismissed his lawsuit based on the case I mentioned, Heck v. Humphrey from 1994. So in Heck, a man named Roy Heck was convicted of killing his wife and filed a Section 1983 lawsuit against his prosecutors, claiming that they destroyed evidence and used illegal techniques. So it's a very tragic fact pattern. It's a very kind of sad circumstance, but that's the kind of legally what was going on in Heck. And the Supreme Court there ruled that he cannot bring a 1983 lawsuit because doing so would necessarily imply the invalidity of his conviction. Basically, him bringing this civil claim could lead to parallel litigation, could lead to conflicting sentences, and could basically force a reanalysis of his criminal conviction. And the proper avenue for him at that point would be habeas corpus. That's a way for a prisoner to challenge the constitutionality of his detention. So in denying Heck the 1983 avenue, he still has habeas corpus, where, again, this is a tragic fact pattern. I don't know actually about how everything kind of in his case worked out or if he was actually guilty of doing this horrible thing. But this was about what is the proper avenue for a man in his circumstance to bring a constitutional claim. And the language and context of Heck make it very clear that the man's claim was denied because allowing him to bring a 1983 lawsuit circumvents the proper avenues and channels in criminal litigation. So Heck comes into this case because the lower court ruled that Olivier's lawsuit was also barred by Heck. Basically, if the court said that if Olivier were to win, there would be the shadow of doubt cast upon his prior conviction. If you remember, he pled no contest and just paid the fee, and they basically said that Heck says you cannot bring a 1983 lawsuit if doing so would invalidate a prior conviction. However, as I mentioned at the start of this, he's only seeking future protection. Nothing in Olivier's lawsuit is actually asking the court to revisit his prior conviction. He's just saying that in the future, this law shouldn't be applied to me since it's an unconstitutional violation of my rights. And the Supreme Court unanimously agreed not that the city ordinance is a violation of his rights, which I think there's a pretty good argument there. They didn't get to the merits, so they just agreed that he can bring this lawsuit. And really kind of what happened in this case is the Supreme Court clarified that Heck needs to be understood in its context, right? The purpose of that decision isn't to deprive people like Gabriel Olivier from any protection in the future. It only applies to people in cases like Roy Heck's. In Olivier's case, there's no risk of parallel litigation or of conflicting judgments. He also never actually would have had the opportunity to bring up habeas relief because he was never actually put in prison, but that was kind of not really brought up by the court, really just because of this first point of he's only looking for prospective relief. Nothing about letting him bring this lawsuit could invalidate a prior conviction. Instead of Heck, an older Supreme Court case that came up beforehand actually controls in this case, as the Supreme Court clarified here. It's this case called Woolley v. Maynard. It's just kind of an interesting fact pattern. A man from New Hampshire there basically covered up the state's motto, live free or die, on his license plate. And in doing so, he broke state law. He was actually convicted and sentenced 3 times under this law. I think he was always given a suspended sentence, so he didn't actually have to go to prison, but he was made to pay fines several times. Basically, he brought a Section 1983 claim saying that the law violates his right to free speech. And the Supreme Court held in his favor. They said that because he's only asking for future protection, he's not asking to annul a prior conviction, he's able to bring this lawsuit legally. It looks very similar to what's happening in Olivier. So why does it matter? I know this is a lot of jargon about Heck, Olivier, Section 1983 claims, but this is actually could be a really important case, really, for asserting constitutional rights generally. As I mentioned before, the court didn't at all address the merits of Olivier's free speech claim. And I can speculate a little bit. Justice Kagan wrote this opinion. I wonder if she was given this opinion really just to keep it narrowly tailored to 1983 and not to touch the merits at all. But I think that actually could expand the impact of this ruling. Instead of deciding that one particular city ordinance is overbroad, which I believe it is in this case, but that's beside the point, the court ruled that people in Olivier's circumstances cannot be denied the possibility of vindicating their rights in court. There's a great line from the court's opinion that puts it creatively, invoking the Greek myths of the Scylla and the Charybdis. And Kagan wrote that, quote, if not able to bring such a suit, Olivier would face the same untenable choice as Maynard. That's the guy from the Woolley case with the New Hampshire law. Violate state law and suffer the consequences, in parentheses, that's the Scylla, or else give up what he takes to be his First Amendment rights, in parentheses, the Charybdis. Scylla and the Charybdis are these Greek mythological sea monsters that live on either side of this narrow strait, and basically ships traveling through that alley would be basically caught between each and face death from either the Scylla or the Charybdis. So the court is basically saying that denying Olivier a forum here forces him to either just continue paying fines and being convicted or give up what he believes are his free speech rights. So by ruling in Olivier's favor, the court clarified that federal law allows individuals whose rights have been violated in the past to seek protection in the future. This case isn't about flooding federal courts with loophole requests from people that are looking for any technicality to avoid facing justice like Heck would have been. Rather, by working with Heck and not in this tension against it, it'll help people like Olivier, average citizens that want to make sure that their basic freedoms are protected.
Yeah, that's a great rundown. I don't have too much to add here. Um, Unlike you who are more disciplined, I can't really help but get aggravated at the substantive free speech argument here. I won't go on about it, but the fact that he was forced into this area for protests is just so absurd on its face because you look at the history of the First Amendment and the purpose of it, right? Political speech in the public square is literally what it exists to protect. And so there are reasonable time, place, manner restrictions that governments can place on speech. Right. But those are for things like this, right? Protests that are going to get out of hand, where if you don't cabin them to a certain area, it can be dangerous. Parades that need permits and certain time, place, and manner restrictions because they shut down streets and they make traffic impossible and so on. That all makes sense, but this guy it's one street preacher. The idea that you need to somehow regulate the time, place, and manner that he is preaching in the public square and limit him to certain places is, I mean, frankly absurd. But on this case itself, I think this is a really important uh, defense for people whose constitutional rights are violated because like you pointed out, Joseph, I mean, the whole idea of Heck was that it's inappropriate and confused for Heck to bring a 1983 claim um, because he's sitting in jail and the proper means of that challenge. There is a proper means of challenge to constitutional violations, which is a habeas action. There's no possibility of a habeas action because Olivier was not in jail at any point. So obviously, they're distinct cases. As you said, that Woolley case is pretty much right on point. This is exactly when 1983 should be appropriate. Just because you pled to a fine does not mean that you should be precluded from 1983, especially when there is a high likelihood of repeat offenses, right? Like, not to be macabre here, but Heck is also distinct because, I mean, he's not. He doesn't murder his spouse as his profession, right? Like, this isn't something he's doing regularly. This is like one thing that landed him in jail was very grave, and he doesn't need his constitutional rights vindicated so that he can ensure that he can do certain things in the future. Whereas Olivier, like the Woolley, sorry, lawsuit where he's covering up the motto on the license plate. This is going to happen again, right? This is part of his beliefs. It's going to be continuous, just like Olivier, who is a preacher, who's going to do this again. Very distinct from Heck. So I'm glad we disposed of this idea that Heck has somehow gotten rid of Woolley and precludes people who are not sitting in jail from using 1983. Because again, there's no habeas protection. So to me, Heck just is completely inapplicable. And final thing, besides our religious liberty and nonprofit work, one of the big things that Napa Legal does is promote the study of the great works that have built Western civilization. We just got back this past weekend from Good Counselor Project retreat with over 30 of our lawyer fellows who are reading the great books. So I love the Scylla and Charybdis analogy that you put into the end of your argument here. So to the people listening, if you have not read Homer's Odyssey, that's where you'll find Scylla and Charybdis, and you should read it because it's excellent. Um, but with that, I will turn to our final subject for the day. Oh, I know we're running a little long, but this one will be quick. We just want to highlight this. This is fairly new. It's still a House bill in Connecticut that is not yet law, so we'll be following this if it goes forward. So in Connecticut, the House Education Committee recently advanced a bill in the House, HB 5468, a bill that troubles me for a couple reasons, partially because of my background as a former litigator in the children and youth services space. So this bill would impose new regulations on parents that choose to homeschool their children. Notably, the bill would automatically involve the state's Department of Children and Families whenever parents decide to withdraw their children from public school, which is crazy. I'll get to that in a minute. The department would basically check for any prior involvement that the department has had with the family, any abuse or neglect or other complaints that have happened to that family in the past before either approving or denying their requests to withdraw from public schools. I have two problems with that sentence. I'll get to them in a minute. So, parents, teachers, department officials recently testified. There's about 19 hours of testimony about the bill's negative effects. Ralph Rodriguez is an attorney with the Homeschool Legal Defense Association. I have friends at that organization. They do great work. If you're not aware of them, you should check them out. Attorney Rodriguez explained that the new bill, quote, creates an implicit presumption that homeschooling parents' choices require justification. Very well said. I'll get to that in a minute. And that this would flip longstanding presumptions in favor flip longstanding presumptions in favor of homeschool families on their head. Additionally, the testimony explains that other measures already exist to protect children in potentially dangerous situations. That's correct. And that homeschooling has no correlation to higher rates of domestic abuse. We've seen a lot of research on this. As Joseph, I know you wrote in our weekly email that'll go out with this podcast, as public schools to continue to produce lower academic proficiency. They have many other problems besides. Many states are actively working to roll back regulatory burdens on parents who wish to homeschool or find other alternative means of educating their children. Connecticut's law, if passed, would I think represent potentially one of the strictest and worst homeschooling regulations that we've seen in this country. I live in Pennsylvania, which has pretty burdensome laws, but nothing quite this bad. So this would be groundbreaking in a bad way. A couple of things I'll note quickly. First, I think that the argument and the purpose behind this bill really gets to the heart of the philosophical disagreement that I think was clear between the majority and the dissent in Mahmoud v. Taylor, which is this: who's primarily responsible for the education and for major decisions made on behalf of children? Is it parents or is it the state? The answer from law, tradition, and I think common sense is obviously parents. Parents are responsible for their children. So I'm troubled by many aspects of this bill for that reason, but I want to specify two. One, the idea that a government agency can approve or deny a request to withdraw children from public schools, just the fact that they have this approval or denial power is absurd and very dangerous, I think. Parents are the educators of children. Public schools are a tool that was created in the 19th century that parents can use if they wish to assist them in their task of educating their children, but it is parents' task to educate their children. So the whole idea that public education is mandatory at all, and that using alternative means of education is a privilege or something that the government can approve or deny is horribly offensive, and I think flies in the face of the sane understanding of how education even works. If you have mandatory education laws, that is, that children need to be educated up to a certain age, fine, I guess. Although I think even there are some fraught issues with parental rights. But to say that therefore public schools are the default and anything else requires justification, it's a horrible problem. So that leads to my second issue here. So the presumption that the choice to homeschool requires any justification, as the HSLDA attorney pointed out in his testimony, it's wrong. Homeschooling is a rational choice. Especially as we said, public schools have been rife with controversy in recent years on everything from the quality of the education to behavioral issues, use of phones and social media, violence on public school campuses, secular progressive indoctrination that is clearly going on from teachers and even in official curricula. There are a million reasons why homeschooling is a rational choice. So therefore, the Department of Children and Families, the idea that these agencies have some presumption that if you choose to withdraw from the public school and homeschool, that's a red flag. Sorry, that's crazy. DCF agencies, or CYS as they're called in Pennsylvania, Children and Youth Services, they have different names in different places. But anyway, they should continue doing the same thing that they've always done. Investigating claims of child abuse or child neglect based on evidence of actual child abuse or child neglect. The decision to opt out of public schools and to homeschool is not evidence or of child abuse or neglect, period. Full stop. It's just not. Um, so using homeschooling as a choice that somehow triggers DCF involvement is completely unacceptable. I mean, I can't even think of an analogy that would make sense. This is so absurd. Like, um, if it's really hard. I can't even think of a good corollary. It's like people make decisions about their children's well-being. If you decide that you're gonna raise your kids vegetarian, that's not a choice that implies homeschool, that implies abuse or neglect. There are plenty of ordinary decisions that families make that just are no business of DCF, right? If you homeschool your kids and then there are separate issues of abuse or neglect that come forward, that's evidence of abuse or neglect. I hate to go on because this is so patently absurd and so obvious, but this is just not how this works, right? DCF is properly alerted and triggered and can launch an investigation if, you know, a child appears in a public place with, marks of abuse, right? If you got strangle marks on your neck, if you look completely disheveled and unfed, if a child is going up to strangers and saying that something's wrong with them. Okay, there are plenty of times where somebody is going to report something to a DCF agency and it warrants a legitimate, first step investigation. The choice to pull your kid out of public school and homeschooling is not only not evidence of abuse or neglect, it's a very sane and rational decision, especially in this day and age. So I should probably step off the soapbox, but this is just so beyond the pale. And given Connecticut's political leanings, I wouldn't be surprised if this advances. But of course, we will keep on top of this and we will be back to this issue if this bill becomes law. So, Joseph, before we wrap up, if you have any last thoughts on this issue, I'll turn it over to you.
Yeah, Frank, like you said, this idea that taking your kid out of public school necessitates the government to come check up on you, it's insane. And this ties into a concept that Napa Legal's done a lot of research on our Faith and Freedom Index. And it's basically, do these laws that impact civic freedoms facilitate or control the work of, in our index, is the work of faith-based nonprofits and organizations. Obviously, it's a little bit of a tangent here because not all homeschooling parents are religious, and our index focuses on nonprofits, but the core concepts are the same that I want to get into a little bit. We'll analyze charitable registration law, tax law, corporate laws, all these kind of different categories of regulatory requirements that impact faith-based nonprofits, really through a lens of facilitation versus control. Laws that facilitate the work of faith-based nonprofits or here homeschooling parents work to support freedom while ensuring illicit behavior, and there are already those things in place. Laws that control just impose these unnecessary regulatory burdens and slow things down and bring the government into spaces that the government doesn't belong. Additionally, as you noted, Frank, they've flipped the presumption of innocence on their head. Laws like the one that Connecticut is considering assume that thus far legally compliant and entirely unsuspicious families need to be subject to this new layer of government oversight because they're taking a step that's rational, especially as we see this huge decline in public schools, both in educational content and parental involvement in the ideologies that they're pushing out. It's a very rational and good idea at this point. And other more effective means of what the government seems to be saying, that we're trying to catch abuse, and if you pull your kid out, it's for some reason a suspicious behavior. If that really is the concern, there are other already effective ways to catch this. It's a serious issue. We obviously want kids to be in safe spaces, but there are other ways to make sure that this happens without checking up on homeschooling families. There is no correlation between high rates of abuse and homeschooling families. There's nothing there. So if the concern really is to catch bad actors, like, yes, we want kids to be in to be in safe spaces, and that's really important. Then follow the laws that already exist and just do a better job there. So while it's a brief point, I just want to note that laws like this that impact civic freedoms can facilitate or control, and here Connecticut clearly is an instance of control, not facilitation.
Yeah, that's a great point. Two final notes on this. One, not only are there good studies showing that homeschooling doesn't indicate higher rates of domestic abuse, but if the government interest is really in preventing um, abuse of children, I think one would do well to take a close look at what's going on in public schools because the rate of abuse of students by teachers, as well as the manifold instances of abuse that take place by students against other students, it's pretty high. It's a serious problem. So maybe look there. And then the other thing I would say too is that the the supporters of these bills will often point to the problem of isolation, right? So well, if people are inclined to have abusive, neglectful environments for their children, they're more likely to homeschool because then their children aren't out at the public schools for hours a day, and nobody will be, nearly as likely to see or to catch the effects of that abuse. Like, okay, first of all, I doubt that there are many serial abusers who are taking the time to homeschool so they can shield that abuse. Maybe it happens, but even that aside, the argument that if parents choose not to subject their children to hours a day of public spaces like public schools, therefore they're more private. We, the government, are worried about how much private time families have, and then therefore we're going to make it the default that if you choose to have your kids at home, we're going to come watch you. Just completely inappropriate, even if the intention is good. Like, no, sorry, if parents and families choose to live mostly private lives, the government doesn't have the ability to say, well, you're not out in public enough, so we're going to come in your house and make sure that there's no abuse or neglect going on. Just wildly inappropriate government overreach, even if, of course, the goal of preventing abuse is a good one. I don't think this is effective, nor is it an appropriate way to accomplish that. And
Yeah, there's plenty of things that we read about that aren't able to make their way on this podcast, and plenty of them are from public schools. There's one that it was recently resolved out of Fort Bragg, but there was a teacher that was, I mean, coming in and forcing kids to call him by like a sexualized version of his name, and he was wearing like very inappropriate clothing. And for years, the school just did nothing. And that's not the only instance that comes up in these sorts of things. So if the government is really interested in preventing kids from being in harmful situations, they need to look at what they're making kids sit through.
yeah, yeah. All right. Well, on that, uh, maybe slightly less positive than usual ending note, we'll conclude this episode. We thank you for joining us, as always, for this episode of the Napa Legal Podcast. If you enjoy the content we're putting out, we always appreciate it if you like the podcast and subscribe to our channel on YouTube, Spotify, or wherever you are listening from. And if you want to know what we're up to, one thing to note, we do have our Good Counselor Project Lawyers Conference coming up on April 23rd. So if you are a lawyer looking for CLE credit of the highest quality, we have some amazing speakers that have now been announced from organizations like ADF and Beckett and many more besides. Really top quality. We're excited about this conference. It's on April 23rd. If you're in the DC area, it'll be at the Catholic University of America. If you're not near the DC area, it is still worth traveling. So come join us. If you want to learn more about the Lawyers Conference or any of the other things we're up to, or if you would like to support us financially, we always appreciate that. You can go to napalegalinstitute.org and get all the information. You can donate, do everything that you want to do regarding Napa Legal Institute. So, with that, we hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious liberty, and particularly the work of faith based nonprofit organizations. We'll talk to you next week. Thank you for joining us, and God bless you all.